गाना में चला देना। आ रहा है। हेलो हेलो हेलो।
also its subsidiaries in their own wisdom to take a reasonable approach and make an endeavor to resolve the issue. But this was pointed out, our solicitor's letter is there, which is in the additional document around at page 15. against the it's from the proceeding. That's it. She said, sorry, that's written to who? Please see the chair at page 424.
Which affects you.
Not the law is as laid down by your lordship.
What part of this order affects you?
The part of the order which affects me is that no proceeding, whether to participate actively or otherwise, constructively or otherwise, can lie once because there is a moratorium against me.
Where is a restraint by the High Court contrary to law here?
Yes, please read it with para 7 at page 4, which I have also challenged. Please see that only for a moment.
All right.
4, para 7.
We'll see that.
Yes, grateful. Para 7. In the circumstances, we are of the opinion that Tehsildar needs to take all steps to advance recoveries as law requires him to do. Now, this part, it has to be made clear that this can't happen. That is not clear. Tehsildar is proceeding.
Were you before the court when this order was passed on the when this order was passed by the High Court?
Yes, I was. This order was prior to the moratorium.
Oh, therefore, prior to the moratorium.
That's that. So it can't now continue. That's all what I'm saying.
When the court passed this order on what is the date of this? 21st of March.
21st. Yes.
The High Court was perfectly justified in passing that order because there was no moratorium as on the date of this order.
Let's assume so, though according to us, no, because the amount is not admitted.
Moratorium, according to you, to being later.
On 28th.
28th.
On that day, Lord, this order should have been stayed. This order is continuing. The Tehsildar is proceeding.
The High Court is seized with the matter. You argue whatever you want to.
Lord, I have pointed it out to the High Court. High Court says you are not to be told that.
All window. This is all. You
go before I am in IRP. Lord, I'm so sorry.
These are all
please
see page 22.
Please see.
Public authority.
Please see page 20. No, Lord, kindly see what has happened here.
Matter coming up before the High Court now.
There is no fixed date.
Only 1 second.
Would your lordship say?
Tripathi is there, not two people arguing. Yes.
I'm sorry, but he appears for the company. Milord, I appear for the IRP. I am purely an IRP. I look
He
after.
appears for the IRP.
I'm together.
Very well. I'm so sorry. I heard his appearance. No. Of course, only one person. I quite see that. Audiatum partum can't be taken to that level, Milord. I see that. I apologize for the confusion.
Why should we interfere at this stage?
No, Milord. May I only
It's
say?
not matter for us to interfere at this
No,
stage.
Lordships may make Milord kindly see. I am Milord answerable to the.
You point out the provisions of law to the High Court. The matter is pending before the High Court. The High Court will deal.
If your Lordships Milord at
Pass
least
an order
directed.
contrary to law, then come here.
And I tell you,
I appreciate that. But may I say this, Milord?
get some.
Milord, may I say this?
Now we are
Milord,
proceeding again.
after 28th of March. Because after 28th of March, the matter has not come up. Would your Lordships please say that on mentioning it will be taken?
Not yes, item 20.
Wait, please. Well, it's a partnership firm that got dissolved long back. And now an erstwhile partner who got his share, everything settled to registered documents, comes back and says there was an income tax right vis-a-vis one of the partners, and then it came to light that he purchased some extra property. That's why everything should be reopened.
Settled, Mr. Shishadri, what was settled before the Lok Adalat
Yes.
was relating to a suit for specific performance.
Yes.
Which was filed by the petitioner's MD of Sama Construction.
Yes.
Now,
He takes advantage of that
you
document.
can always raise all defenses under Section 16.
May I submit one thing?
Yes.
Gross abuse of process, in the sense, once they've all retired and they've just left Millers, now they've been drawn back into this cauldron of litigation for no reason, just because he wanted to have an extra pound of flesh. There could have been other ways, Millers. My lords may kindly see Millers. The reason he has given, he says that it was an antedated document which was executed in 2015 as if it had been executed in 2007. He willingly, according to him, subscribed to that one.
There's a settlement or otherwise will be looked into by the arbitrator.
My lords may kindly see one look at page 11 minutes,
That's my
where the plea has been taken, the document is void, not even a sentence should be binding on either any of the parties to that one.
That's it.
Still he says that I should invoke the arbitration.
You can still argue that before the arbitrator,
Millets.
whether the document is void or otherwise.
When the
will be
document has
decided
been robbed of its validity because of, they say that a fabricated one, Millets.
by the case for us to interfere.
And Millets, in fact, through
They
a
have
registered
appointed an arbitrator,
document, he
correct?
got his share.
The High Court under Section 11 could not have gone into these issues, Mr. Shihadi.
Precisely, Millets. And my lords, may kindly have a look at page
Therefore,
11.
they've appointed an arbitrator. You argue whatever you want to before the arbitrator. Thank you. Dismissed, yes.
May I just plead, Millets? May I plead one thing, Millets?
Yes.
May I plead, Millets, since your lordships, it's fallen from your lordships, please allow us to have that as a preliminary issue. And then, if at all it survives, then I could face it. Otherwise, it has to be shut out.
What is your, who are you appearing for?
It's corrected, man.
Slightly different argument. Clarification from your lordships may suffice, Vinod. Your lordships be kind enough to see the arbitration clause, Vinod, which is at.
What is your contention?
Vinod, my contention is this, Vinod, that the arbitration clause is limited. There are two agreements, 2007 and 2015. Arbitration clause is only the first agreement, but admittedly there is no arbitration clause in the second agreement.
Raise that under Section 7,
That's
under
all,
Section
that's
16.
all that I'm saying. The prayer that has been allowed is reference of disputes under both agreements.
But you can
Yes,
raise.
please clarify that.
Why do we have to say that? You have a remedy under Section 16. Why should we clarify something which is
Isn't
implicit
he?
here?
Please see the order of reference.
You can look. Parties know what they can raise under Section 16. We are not going to give any such.
Millets will not be
Raise
troubling your
whatever
lordships,
you want.
Millets. Will not be
Thank you.
troubling. Please
Next matter.
kindly observe, Millets.
Shadri, thank you.
If at all we raise, Millets, let it be a preliminary issue, so that
Not
you will not
do
go
anything
through the
on
whole
the-
hog of the
sorry.
litigation.
So arbitration gets absolutely goes for a toss. Yes.
Millets, in the absence of Millets, my instruction is that, Millets, may I just plead, Millets. It will have the stigma of dismissal.
All right.
You only get best there.
Item 21, then 21 years.
Stigma of dismissal.
After noted, there's a petition under section 11 of the Arbitration Act.
Yes.
But last time on 14th of August when the matter came up, your lordship had asked me to give three names of retired judges. I gave three names. One was Justice K.L. Vadne, Justice Davre, and Justice Saleh. On 18th of, it was listed on 18th of August for that purpose only. On that day, my friend sought time, and therefore your lordship had imposed a cost of 1 lakh on 18th of August. Now, out of these three, what happens in between is when I file a petition before your lordship, they appoint one lawyer unilaterally without my consent and get an award passed in their favor. Your lordship indicated to them this can't sustain. You choose one amongst retired judges, or you choose any one retired judge.
Now,
And
whom do you want to go to arbitration?
Can I just make two respectful submissions? First, in terms of, I wasn't there at the last hearing, so I don't know what transpired. So for my learned friend to say that, well, everything, I don't have to argue anything and we're only looking at appointment of an arbitrator, effectively means that I have nothing to say. But if your lordships looks at the dates, please see what has happened. I wrote to them and I sent them a notice of arbitration. They have never issued a notice of arbitration on their own. So whether they have a section 11 that's maintainable without a notice of arbitration is very questionable in light of your lordship's recent judgment, which your lordship pronounced in April. Second, in my notice of arbitration, I named an arbitrator. They go to the Bombay High Court, after which they come here. They withdraw the SLP here saying we'll file a section 11. They take 14 months to cure that defect in the section 11, refuse to participate before that arbitrator, who awards my claim. What is the claim? They took 2.5 crores from me, my money, did not supply a single machinery to me for 5 years, agreed to give the money back to me. When they didn't give it back to me is when I invoked arbitration. And now they don't have a dispute. That's why they don't even have a section 21 notice. So how does the section 11 lie at this stage? Without a section 21 notice, how
How
do
do you issue a notice under section 21?
They've never done it.
Mr. Chaudhary.
what happens is this, Milord. It is
He
there.
issued a notice for arbitration to you on 23rd of December 2019. Sorry. He actually issued a notice on 3rd of April 2019.
Yes.
They invoked arbitration. Am I right?
That's correct. But then 20
What happens is you object to that on 16th of April 2019.
Yes.
And then they, on 23rd of December 19, they say that they are appointing that Shivom Garg.
That's correct.
That is wrong. You couldn't have unilaterally appointed.
But they filed a
One more factor.
But look at the complete fraud in the process. You just unilaterally appoint an
I
arbitrator.
didn't unilaterally. I said, if you
You had to
don't
move it.
please see the predicament I am
Mr.
in.
Diwan, look, Mr. Diwan, you are from Mozambique.
Yeah. Yes, that's correct.
Why don't you?
I'm the buyer. I'm the one who's paid.
Why don't you both agree to an arbitrator? As we last time said, you both agree to an arbitrator who's a retired district judge, a retired high court judge, a retired some council here, and we'll send it to a council. You tell us who you want to go. Because it's not a large game. It's what, 2.5 crores.
There's only one very interesting point that comes.
2.5 crores, right?
3.5 crores now they get.
The quantum is not very much. I accept that.
See, any of these retired judges, I gave three names, they give any name, I'll choose one.
The quantum isn't much, and I don't want to detain your lordship beyond the point. I have an award in my favor.
But it's only a paper award. I mean,
They're telling me.
How could you have just unilaterally appointed?
I didn't unilaterally appoint. I said
You had to move a section 11.
Plus, I could have. I'm not saying
You had. There's the only remedy. You can't say I'll appoint whoever I want and he'll be a sole arbitrator.
I said, if you don't object, it will be assumed that you agree to the other.
Not the law. You have to move the court under 11. So now tell us. That's why now it's come up after what? Nearly 11 months.
That was kept specifically for this purpose.
Now tell us. You need not take one of the three arbitrators they have named. You tell us whom should we appoint. Where is the arbitration to take place?
Pune. And he appoints someone here.
Plus, can we get a lawyer
From this court.
Plus, your lordships may appoint a lawyer from this court.
लाना फोन लाना
From our court or?
This point, I
have no problem.
This court. Lord, it's only one aspect. Your Lordship may clarify, because I actually technically have an award in my favor, which has not been challenged. I might have to raise it again, because otherwise,
that's what
all
all
this
this
down.
We'll just say, bearing in mind the arbitration agreement between the parties, bearing in mind the arbitration agreement between the parties, Ms. Archana Pathak Dave, Senior Counsel, is appointed as sole arbitrator to adjudicate upon all the claims and differences. Full stop. The arbitrator shall fix her fees in consultation with the parties.
It's deeply grateful. I am so good.
Arbitration petitions accordingly disposed of.
Item 22.
I am so good.
This is the matter about the uniform.
Yes, now, yes. I remember this, the matter came up last on 7th of March, I think. When is the mention?
that-
Before that, 9th of January.
9th of January.
Now, what is the position as Ms. Bhatti?
Lordship would recall, what my lords had asked us was to give a roadmap.
For the future, yeah.
So the suggestion was, my lords, from our side, that the agreement can have Part A clauses which would be there, and Part B would be incorporated by the states depending upon the local laws, which would not be inconsistent with RERA. So we had accordingly prepared and we had given for Lordship's consideration. Lordship had then directed us that let all the states give their responses and then a final Part A clause can be placed. So this third status report, my lords, after considering all the suggestions from the states, the final Part A clauses have been placed for your Lordship's consideration. This was filed on 5th of July, my lords. Your Lordship would file in your Lordship's file at page 2665. The additional.
The additional, right? It's 3. Six, 3. 6, 3. 5, actually.
Lordship's e-file, it would be serial number 34, the last one.
It appears that this, your last report, can we keep it tomorrow or day after, whenever you want? Because we'll have them uploaded because we have not seen it.
Lordship,
So now you have prepared model builder buyer agreement.
My lord.
Part A is the general agreement, which is consistent with the RERA.
Lordship.
Part B will be the state-specific conditions.
Lordship.
For instance, Maharashtra is a slum rehabilitation authority,
So
so on and so forth.
Even Haryana,
Now,
etc., they would.
has it been circulated to all the states?
Responses have been received. We have actually looked into each of those responses. We have given a table also as our first annexure, giving the comments and accordingly incorporating those suggestions in the party clauses.
Oh, I see. Can we just do this, maybe take it up tomorrow or day after, because we have not
Absolutely.
seen the last, and all three of us, our brief ends at page 2663,
My lord.
2665. Mr. Mishra, what do you have to say?
Listen, Mr. B. Accuracy has done a human job. Problem will not state of Haryana. It's a critical will not state your lordships are aware because maximum development is taking place there. But there, did I am going for did I and your lordship will kindly permit us. But our reservations have not been taken into account at all, Lord, with the greatest respect to the learned amicus. Number one. While other states will not, he is given much greater weightage. That's number one. Number two, there are unique features as far as state of Haryana is concerned, where your lordships have now laid down the law over the past 3-4 years. My lord, the Chief Justice himself. For instance, very simple, my lord. When should compensation start kicking off? On the date of valid offer of possession, or on the date when possession is actually, my lord, handed over? Your lordships have held. The builder, my lord, the onus is on the builder to give a valid offer of possession after due OC is received. But when the buyer comes to take possession, is up to him. I have no control over that. So, my lord, here the onus is sought to be shifted. When the buyer takes possession, the builder must continue to pay. The buyer will never come to take possession because, my lord, he is getting 9% interest or 7% interest here. So he will wait for 2 years, 3 years, 4 years. So it will, and even under RERA, he will get 10% interest.
What is to be done now? If there are any subsisting objections about
the
the
other problem is- the other-
One second, yes. What do we, you are appealing for the state of Maharashtra? or-
I would like to take instruction on this note, my lord, because I don't find anything about Maharashtra. I'll just take instruction. 1 week if the lordship keeps.
How do we now deal with these, whatever remaining objections are there, Ms. Bhatti and Mr. Maruka, Mr. Upadhyay, what do we do about these kind of objections now which have been raised?
There are three, my lord, there are three states. One is state of Nagaland, which notes that because of Article 371 capital A, RERA would not apply at all. Now, I believe I had a discussion with the ministry officials. They are actually in touch with the state government and trying to sort out that issue. That may not really come on way. And also, I believe, Maras, another petition is pending consideration before your lordship, where also the RERA implementation as an issue itself is continuing in terms of the entire country. Secondly, Maras, the state of Tamil Nadu has indicated that they have actually got 2 agreements instead of 1. So we have indicated, Maras, in the report that 2 agreements cannot really be done. It should be 1 because anyway, it's across the country, it's a single agreement, and that's the scheme of the RERA. So as Haryana is concerned, I had the occasion of sitting with my learned senior friend with respect to the matter. Whereas there, to my understanding, it's really about certain local laws like the Haryana Ownership Apartments Act, etc., where they seem to be slightly in conflict. Now, they are placed on record, and I will show the affidavit, a certain order of the government of Haryana saying that because of these conflicts, they have issued a letter internally that the local laws would apply as opposed to RERA. And in the latest Haryana affidavit, a response to these clauses, they have said that in the rules, they have amended the rules in a way so that they are able to adjust this conflict. Only my submission, conflict between state and center, probably the state would have to in some way give way to that. So that's a Haryana probably is an area which probably a lordship would want to hear. Otherwise, my lords, in my submission, otherwise the entire states, all the entire country should not hear.
My colleague, so I'm grateful.
The Union Ministry has worked extensively. But my lords, it is consultation and legwork of the ministry itself.
So perhaps what we do is,
My lord, as far as
3 days, let's read their reporting. We'll also see the report of the amicus. We will hear whatever objections say CRIDAI has, and in the meantime, you take instructions for the state of Maharashtra. And if something remains, we will deal with it and otherwise resolve it. Because now we'll take that on the record. Prima facie, we should take these agreements on the record and see that all states will have to implement this, because there has to be some uniformity otherwise.
my lord, as far as Nagaland is concerned,
Nagaland, they are looking into it. They are in touch with the chief secretary, they said.
in fact, we want to refer the matter in terms of the constitution to a committee which is constituted by the Legislative Assembly of Nagaland, specifically for looking into whether the laws are in consonance with Article 371.
We can, Nagaland specific issue, we can keep aside a little bit. Because, we need not allow the Nagaland issue to sort of, because this is vital for the entire country. Otherwise, buyers all over the country are being defrauded by builders. Now, if we have one model agreement, at least there'll be some guarantee that, there is some uniformity in what builders impose on buyers. Nagaland, I quite see, this is a Article 371A issue. We'll keep it slightly out of the picture for the present. And you also take instructions on what is the way forward insofar as Nagaland is concerned.
Meeting is happening today. RERA itself applicability. So when it becomes applicable, it will be done.
So we can create an exception today for Nagaland. That's all.
Discuss my friend, and he agree with me. The basic thing, madam, we are constructing. First thing, we should be in the human manner. What is the strength, strength of the foundation?
That's all right. Therefore, now the model agreement covers these aspects.
No,
My lords, there is a Schedule D which says specifications, amenities, etc.
Okay.
It's my understanding that is where it should fall. It cannot really be otherwise.
It has to be in specifications.
Yes, madam.
Otherwise,
We'll keep it on Thursday. We'll hear you for 5
Depends if
minutes.
the column stays is M20 or M25, M30, but it's
All right. We'll look at it at that. All.
my lords, may I just make a request? Your Lordship may consider, kindly have it on next Wednesday. Thursday, I'm somewhere.
Not this Thursday.
Yes.
All right. Monday.
Next Monday.
Monday or
Wednesday.
Friday.
Actually, it's a family marriage, so that's why I'm.
Keep it next Friday then.
I'm so grateful.
We'll keep it Friday week. Then.
I'm
Friday week. Mr. Baruka, just make sure that it is the report which has been prepared. The report which has been prepared by Mr. Devashi Baruka, Learned Senior Counsel, in consultation with the Ministry of Housing and Urban Development. The Union Ministry of Housing and Urban Development has not been scanned and prepared and placed in the record. The registry shall ensure that this is done by the next date of listing. Full stop. If any counsel appearing in the matter who desires digital copies of the report of the amicus curiae shall be at liberty to obtain copies from the registry. List on, we'll keep it Friday week so that we can dispose it of.
In fact, I must say, I was able to actually download this from the e-filing website, so probably it's there available on the.
It's there, but somehow it's not being provided to us. All right.
My Lord, may mention also, as far as state of Nagaland is concerned, it can be taken up.
Today the meeting is being held, so that we are not saying anything about Nagaland for the reason that Ms. Bhatti said today a meeting is being held.
No, I am conscious of it. I am a member of that committee of the
Tell us next time. We are not passing any order for implementation today. So there's no order for implementation by any state or UT today. So let's apprise us on the next date what happens about the state of Nagaland.
The item 23 also, there is an error on our part. We have not filed that affidavit, my lords. That affidavit, we assumed it was filed. It's notarized in February. The accessibility guidelines have been framed after the committee was constituted. We reported, your lordships may consider.
Keep it next week.
Please.
Report.
Service complaint. Claim is about $2 lakhs, 200,000 $.
Yes. And on our part, we